Hi, my name is Eric Willison, and this is Fatlock on Evidence. Today we're going to talk about hearsay. Now, before we get to that, let's take a look at what we've been over so far. We've already talked about the rules of evidence, talked about what is evidence, if it's relevant, comes in, unless there's a rule against that relevant evidence coming in. We talked a little bit about Rule 403 in past videos as the first set of rules that keep certain relevant evidence from coming in. Now we're going to talk about a second type of evidence. It's called hearsay. And hearsay evidence, in most cases, is not going to come in, subject to some exceptions. But we got to figure out what hearsay evidence is. Now, let's start off with a common misconception that most lay people have. Listen up, lay people, that's you. Hearsay evidence is not he said, she said evidence. A lot of people tell me, oh, that's all just hearsay evidence because that's just all he said, she said. Whether evidence is conflicting or not from two different witnesses does not make it hearsay. That's not hearsay evidence. So what is hearsay evidence? Fortunately, I've got that all figured out. We're going to look at three things. We'll look at this common misconception first. And hearsay evidence is under Evidence Rule 801. Hearsay, I'm going to give you the technical definition first. It might not make any sense at first, but don't worry. Don't worry. I'm going to put it into English for you. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Now, before we forget, I've got a high-tech aid here. Oh my goodness. High-tech like nobody's ever seen before. Look at that. This is like high-tech stuff from the 1950s. Introduction to hearsay. Not he said, she said. It just follows everything that I just said. It's amazing. And now we're going to look at the two elements of hearsay. Now, all this stuff about the declarant and at the hearing and testifying and all, let's put it into slightly more user-friendly language, a little bit more language for the layperson. This does come from a court, by the way. And it says, to constitute hearsay, two elements are required. And look at that, two elements. Two elements are required. First, there must be an out-of-court statement. Out-of-court statement. It's just amazing, this thing. And second, the statement must be offered to prove the truth of the matter asserted. If either of the elements is missing, then you don't have hearsay, and you don't have to worry about it, okay? So, what is this truth of the matter asserted, and what is this out-of-court statement? Obviously, we're going to put somebody up on the stand, and anything that guy says, well, it's an in-court statement, right? Well, yes, but what if that person, he or she, is referring to something in his or her testimony, referring to something that somebody else said from back during when all this occurred. So let's give an example, and this is going to tie in the second one too. It's got to be offered for its truth, okay? So let's look at an example here. David is a practical joker, and during a crowded movie showing, he lights off a smoke bomb and he tosses it down the aisle where it starts sort of quietly fizzing and smoke starts coming up. Now, some unidentified man who's a moviegoer, it sort of lands near him and he's the first one to smell it. And he starts shouting, "Fire, fire!" And in the ensuing panic, where everybody's trying to get out of this movie theater at the same time, during this ensuing panic, Amy gets trampled on. And when she's trampled on, it severely injures her. So the lawyer puts Amy on. Amy's lawyer calls her to the stand during the trial because they found out that this David guy did it somehow. And so Amy sues David, and Amy's lawyer puts Amy on the stand and asks her, he says, now you went to the movie, did anything strange happen during the movie? And Amy starts to answer, and she says, well, yeah, right about 15 minutes into the movie, some man near the aisle stands up and starts shouting, fire, fire. All of a sudden, David's lawyer says, wait a minute, wait a minute, wait a minute. Hold on. Objection, Your Honor. Hearsay. And the judge, for the purposes of our explanation here, is going to go, hearsay. I've heard something about that. Tell me more, counsel. Well, Your Honor, hearsay has two elements. And we got an out-of-court statement here, Your Honor. And it's because it's not Amy's statement that we're talking about. It's the statement of this unidentified man. So that's the out-of-court statement that we're talking about. See, Amy is the declarant. She's the one that is talking about, other than the one made by the declarant. So Amy is the one who's relating what's being said, okay? But she's not saying she shouted fire. She's saying some unidentified man is shouting fire. And so that's an out-of-court statement, and it's being offered for its truth, Your Honor, says David's lawyer. And he says it in that way because he's just realized he just cooked himself, because it's not being offered for its truth. Amy, no one in this case is arguing that there actually was a fire. Everybody agrees this is a practical joke and a bad one, and that there was no fire. It was all just to see everybody run around like chickens without their heads. And so we're not trying to prove that there was a fire. So the fact that this guy gets up and yells, fire, fire, it's not being offered for its truth. It's being offered by Amy's lawyer to show the reaction, the fact that the guy did say something and the reaction to it. Nothing to do about whether there actually was a fire or not. So this statement that Amy is testifying about would actually not be hearsay. So even though it's an out-of-court statement by some unknown guy, it's not being offered for its truth, so it's not hearsay. Not hearsay. Now, why don't we like hearsay? We don't like hearsay because we can't really trust it. Let's look at what another court said. And it says, the foregoing rule, which we just talked about, the out-of-court statement offered for its truth, governs the admissibility of out-of-court statements. The basic rationale for excluding hearsay testimony is its potential for inaccuracy. In essence, information obtained from a person directly is likely to be more accurate information than information you obtain from some intermediary. Okay? So why is this? Well, let's assume for a minute that the person that is doing this testimony through another was actually a very honest person, okay? Let's say that this unidentified guy who shouted fire, fire is known for, let's say we find out his name is Wally, and Wally, the witness, is known for his honesty all throughout the town. There's no doubt about the fact that he's trying to get one over on somebody, okay? But even if Wally, and let's take it out of the fire incident, okay? Let's say that he heard somebody say that he killed somebody, that the other person killed somebody. Well, we as the people sitting in trial, the people who have a jury deciding their fate or a judge deciding their fate, we want to be able to sort of look at this person who actually makes the statement. And we want to be able to discern for ourselves whether this person is telling the truth or not. That's one of the big strengths of our judicial system, is the ability of lawyers to cross-examine witnesses and try to trip them up if they are lying, to try to trip them up and show the jury, no, you can't trust this person because what this person is saying is impossible, and we caught him in a lie, okay? Well, you can't do that very, very easily if you've got to do that through some other person who's relating what got said. So, let's say we have a situation like the example from the movie My Cousin Vinny. There was a character from the New York area, maybe New York, New Jersey area. I believe the character is played by the actor Ralph Macchio. And the character is being questioned by the police. And the policeman says, and so that's when you killed him. And the guy says, I killed him. Well, anybody from New York understands that's not an admission. That's a statement of surprise. I killed him. In other words, why are you accusing me of killing him? But if somebody else who's not from New York, maybe the person is from Nebraska or from Alabama or from California, and hears that statement, and he says, yeah, the police officer asked him, and said, so that's when you killed him, and he said, I killed him. But you see, we don't get that. We don't get that tone, that intonation that the actual person who made the statement in that situation stated. So that's the problem. Now, in this, would have been an exception maybe because of the fact that there was a statement against interest, but it just to illustrate the issue of the fact that a person who's relating something that someone else said to a jury, even if that person is very, very honest, could be missing the tone, the jury might catch on to. Maybe there's somebody on the jury that's from the Northeast and can explain to the rest of the jury, had that person actually been brought in and said, I killed him, then you can say, no, that's just how people talk in the Northeast. That's not an admission, guys. Come on now. So that's one thing. Also, you may not catch sarcasm. So someone might say, yeah, I pulled the hammer out of the drawer in the bathroom, and then I hit him over the head with it. Well, the person's being sarcastic, okay? Someone hearing that, sometimes people don't catch sarcasm. And so that sarcasm is lost. So there's a lot of reasons why even an honest person who is trying to relate what is being said as far as the hearsay goes, we prefer not to even take hearsay from honest people. Now, let's forget about honesty now. Let's say that the person who's trying to bring in and testify about this statement made by somebody else is not a very honest person, okay? Well, again, we can't cross-examine the original maker of the statement, and what we have to do now is we have to kind of believe what this other person said. Now, the other person may be giving a literal truth as to what that out-of-court statement was, but he could be shading it, or she could be exaggerating it a little bit here and there, and we wouldn't know for sure because we don't know what that out-of-court person, we don't get to actually put that person on the stand and ask that person who actually did sense this and all that. Also, the person who's the out-of-court statement maker, that person may not be honest. but that person bears no risk of an out-of-court illegal or dishonest statement, I should say, because that person's not under oath out in the world. If that person says, oh yeah, the light was red when the black car went through and hit the green car. Well, there's no law against lying to somebody out there on the street. If, you know, assuming that person's that was lied to was not a police officer taking a report or whatever, just, you know, talking to some other bystander who might have had his or her back turned and then turned around when there was when they heard the crash, and then the guy says, oh yeah, this car had the red light. Well, that's not true. But you see, now we can't cross-examine that because all we have is the person who said, yeah, and then Frank said that the light was red. Well, how can we do that? We can't cross-examine. What if that's Frank's cousin driving the car? Now, the witness may not understand that that's Frank's cousin, and we'll never know. But a really talented attorney who's cross-examining Frank would say, wait a minute now, and he'll have done his research, or she'll have done her research, and she'll say to Frank, wasn't that your cousin that was driving the car? Yeah. And you said the light was red? Yeah. Oh, I see. Okay, now the jury's got something to go on in their mind. So there's a lot of reasons why you don't want to trust hearsay, why the court doesn't want to trust hearsay. There's even a constitutional rule against hearsay, which is that in the Sixth Amendment, in criminal cases, you've got the right to confront witnesses against you. And so if they're bringing in somebody to say what somebody else said about what you did, well, how do you confront that person out on the street who said what supposedly you did? You don't get to do that. So there's even a constitutional protection against hearsay. Now, there are exceptions to the hearsay rule, and I'm not going to get into them all. I'm just going to give you 3 of the many exceptions to the hearsay rule and just sort of give you a quick showing of why each exception exists and how that exception is based upon something that will sort of allay the court's concerns about hearsay that we just talked about, okay? So the first exception would be what's called an excited utterance. The second would be a present sense impression. And the third would be a statement for the purposes of medical treatment, okay? So the first would be an excited utterance. You're at some amusement park, and you hear this strange, you're near a roller coaster, you hear this strange sort of a cracking noise, and you look up, and then you see the roller coaster is coming apart, and it just comes off the rail and crashes. And the guy turns to somebody else who hadn't seen it and says, holy cow, did you see that? There's that cracking noise, and then the rail cracked and the whole thing came down. It's amazing. He's excited. He has no chance to sort of consider what just happened and think, wow, these guys probably have a really good lawsuit against the amusement park. Wow, I could maybe be a witness and get paid for all this and get paid to come in and testify. He hasn't had any chance to work that through his or her mind yet, okay? So the fact that it's a present sense impression, an excited utterance, he's so excited that it's not likely that a person who's excited like that and under the immediate influence of the excitement of this event, it's not altogether likely that they would lie, okay? So that sort of, not totally, but it sort of allays a lot of the court's fears about the fact that this might be an inaccurate statement, the guy might be lying about it, or whatever, who knows. So, but it's just enough to maybe let it in as an excited utterance, okay? Now, I'm going to get into, the problems with excited utterances and all of the other hearsay exceptions in different videos. I'm just giving this for just a general impression of there are exceptions and here's why each exception exists. The next one's a present sense impression, and that's very close to what we just talked about. Here's a guy walking along, and all of a sudden he goes, "Ow, my foot!" And you know, the guy looks down, and everybody looks down, and there's a bear trap that just closed on his foot. Okay. Well, now we can bring in the people who heard him yell, "Oh, my foot," to say, okay, this guy was sensing pain. This wasn't something where the bear trap just didn't really function correctly, and it just closed on his leg, and it was an inconvenience until they got it off. And he was just sort of faking the fact that, you know, oh, my foot, okay? But if you heard it click and the guy yells, "Oh, my foot," that's a present sense impression. And again, the guy has not had the chance. He was taken by surprise by this, and he hasn't had the chance to consider, oh, gee, if I really yell out loud here and say, "Oh, ouch, my foot," then I could probably, you know, get a better insurance settlement out of this than I could if I didn't do that. So there's the issue there that, again, it's related to the excited utterance, but it's a present sense impression of the pain. Okay, so other people could testify as to the fact that he did yell this. All right. Now the third would be statements for the purposes of medical treatment. Let's say, same example, the guy has the bear trap collapse on him, and he goes to the hospital about 45 minutes later, and the doctor says, "What happened to you?" Or the nurse says, "What happened to you?" And he says, "Well, I was out hiking and a bear trap closed on my ankle, and that's what caused this." Okay, well, why is that going to be more accurate or accurate enough to allay the court's concerns about hearsay? And the reason is that a logical person doesn't lie to his doctor or the nurse who works for the doctor and is collecting the facts about the situation, because he doesn't want to say a bee stung me on my ankle, and that's what this mark is, because they're going to say, "Oh, well, then, okay, well, bee sting, you're not allergic to bee stings, are you? No? Okay, we'll go home." Well, but if that bear trap was rusty and it broke the skin, he might get tetanus. And so it would behoove him to tell the doctor honestly what happened. Yeah, a bear trap snapped on my ankle. Oh, is it an old bear trap or a new bear trap? Was it dirty? Was it clean? You know, they're going to want to know all this because the guy might have an infection now, and they might want that'll change which shots they might want to give him to make sure that there was nothing on that bear trap that's going to infect him and cause blood poisoning or gosh knows what. So because people are generally honest with their doctors, if they're genuinely seeking medical treatment, then that's enough in that situation to allay enough of the court's concerns about hearsay to let it in. Okay? So, again, those are just a few of the exceptions to the hearsay rules, and I'm just trying to show you that why they're there, because you may want to object to something that you feel is hearsay, and you want to always put in the fact that it's not just the rule. You want to put in the fact that, Your Honor, the reason for this rule is that we can trust this sort of evidence because it doesn't run afoul of the court's fears as to why hearsay shouldn't come in anyway. So that's the rules on hearsay. It's not he said, she said. There's two elements. It's an out-of-court statement offered for its truth. Remember, if it's not offered for its truth, that's not an exception to hearsay. It's just not hearsay. We talked about why the courts don't like hearsay, and we talked about exceptions to hearsay. Now, if you're a law school student and you're if we're doing this as an evidence exam, you need to be keen and understand the difference between when something isn't hearsay and when something is hearsay, but there's an exception. You can get a few extra points on an exam for that kind of thing. So, That's the broad impression for hearsay. We're going to get into much more specific stuff later on. This is Fatlock on Evidence, and we've been talking today about hearsay.